Yo, it's not a black or white thing. It's a do the right thing moment. Man, they over there tearing that lady up. Let's go straight to it. Hey yo, a lot of y'all say you're hot, some of y'all in denial. Yeah, yo, how you know what she did to support her kid's son? How you know? Yeah, yo, you say that's your boy, but you better say watch him. Yeah, yo, why you think you know everything when you know nothing? Yeah, yo, I threw away the gun, y'all. No, I'm lying. I grip iron, protect my life like I'm not dying. Y'all stop trying, mama stop crying. Yeah, so once again, that's my song right there, In Denial, because a lot of y'all out here, a lot of y'all say you're hot, some of y'all in denial. And for real, down there in Georgia, so a lot of them in denial down there. Hey, we're going to get straight to it. Yo, Ashleigh Merchant, that's her name. Boy, she down there spilling all the goods. We're going to get straight to it, y'all. Come on. Don't even worry about it. Let's go. Let me jump past this, because they down there getting it in. They down there getting it in. When I say they getting it in, they getting it in, y'all. Man, Fani, I don't know if she going to have a career after this one. She might not. I don't know. Y'all let me know in the comments section.
Saying I was hiding things, and I explained to them, I let them look through my phone, they scrolled through all my texts.
Who's they?
It was Adam Abate was the prosecutor.
Okay.
So he just kept saying, that where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete, rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word. But, there were some that Miss Willis's daughter had failed out. Like, things like that. They were just ugly. They didn't need to be admitted.
Oh, yeah, I read that.
So I had tried really hard to just screenshot the relevant ones, but they kept hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20-$30 and took 3 hours, and I was very proud of myself for finally figuring out how to do it. But I was able to make a copy of it and then redact our phone numbers. So this actually showed when they're read, when they're viewed.
What were you? All right, so up there on January 5th at 9:50 a.m. Mm-hmm. You're asking, what do you, read the question.
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact checking line by line, basically.
Right. So did you send him a copy of your proposed motion?
I did, and I actually admitted. So at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it, and then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded, and then he responded that everything looked good. Because I asked, I said, I'm sending you this motion. I need you to look at it. And then he responded that everything looked good in it. Right. He actually told me at first he wanted me to make some changes because I had not included the information about how much money he had received. I had only included the information about how much Wade had received. And, I didn't know that it wasn't really highly relevant to my motion, but he was like, oh, that's going to tip them off that I'm talking to you, and he did not want anybody to know that he was talking. He was very concerned about what
I'm going to let
happened.
you just read through this chain.
Okay.
All right. We left off
Boy,
up
she
there.
going to get it in, boy. She going to get it in.
Absolutely.
It's crazy.
Began before it began when she was a judge
That's
in
a
South
Senate.
Fulton. When was she a judge in South Fulton?
She became a judge in August of 2019. And I did an open records. I first asked, I first did an open records and they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges.
So for y'all, check it out. So I ain't mean to stop her, but wait a minute, check it out. But in the beginning, I'm on some time right quick, so I got to do this real quick. You know what I'm saying? I'm trying to get it in for y'all. Look, she gave up the what she did. She talking about how much money they made, how much he got paid, how much the other people got paid. They checked out his bill and stuff. I said, yo, I got to get on this. I got to get the people to hot the goods, man. Come on, y'all.
So I got the
Who's both? You mean Wade was the judge at the time also?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So and it was in person. So I could narrow it down because of COVID. I figured out when COVID happened and when, all the conferences went virtual. Narrowed down my timeline, so I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019. Right. So I found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like a list of attendees because I wanted to verify Miss Willis went there because I was trying to fact check. And they said no. So I subpoenaed them and they gave it to me. I also subpoenaed.
Was she in attendance?
She was. I also.
Where was that conference?
It was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from two different sources that she attended that conference, and that matched what Mr. Bradley had told me.
All right. So is that a part-time job, a municipal court job, Judge?
Yes,
okay.
It is.
So Wade could continue practicing law and do that on the side?
So she was a full-time, but Wade is a part-time, and Wade only did maybe once or twice a month at most, because he was in the city of Marietta. I mean, he was he was a fill-in judge for that. That wasn't his.
Okay, so you narrowed it down to that's when the relationship began. Scroll through here for us, and I can't read that green writing. What's
okay.
the next? If you don't mind, just sort of read
No, of course.
through.
It says, "Is this accurate?" And this was again on
So when you're saying, "Is this accurate?" You're going over this brief and saying, I'm about to swear this in court. Will you verify it's accurate?
Yes.
Okay.
So at that time, I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court, and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12-something p.m. on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their other law partner?
Yes.
Okay.
And I did not disclose Mr. Bradley in my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what?
Multiple reasons. I mean, it's the district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in, to be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when? Yes,
and he changed his testimony somewhat. At first, when he first testified, he testified that he had never discussed this with me. And
then you showed his text messages where y'all discussed it.
Well, at that point, that caught me off guard. So, I didn't expect
See
that.
how they laughing and stuff like that? That's the cynic, man. Look, these folks is not playing. Fani, you might be done for it. I'm just saying. I mean, she told all the stuff. She said stuff in here, man. I wish I was gonna go back. I'm gonna go back. I'm probably gonna do one this weekend for y'all, and break it really down. Man, she went back. She told stuff that wasn't even in the courtrooms. You know what I'm saying? The stuff that she probably couldn't say. She said it on here. She told them, y'all better watch out who y'all be spilling y'all stuff to. Don't tell everybody all your business, because you never know, it might bite you. It might come back and bite you in the arm,
So then I pulled my text messages, and I'd had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that yes, he had.
had told you that?
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not
He acknowledged the relationship, yes.
before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther
Yeah,
King.
walk us through that. What were the grounds why is it you feel like Fani Willis should be disqualified from continuing this prosecution?
Yeah, and so and these are things that I alleged in my initial motion that was filed on January 8th. I outlined this. My client in particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He was not a subject. He wasn't part of that. So he was added on.
That's interesting, because I remember hearing that the special grand jury had recommended prosecuting like 40-something people.
They had.
He
yes.
was not even in that list of 40?
He was not.
And they didn't take, or they, as in Fani Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called "Find Me the Votes," that authors had exclusive access to her, and so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. You know, and I mean, I have
Was that because they cut deals with them, immunity deals, or?
Some of them were that. Some of them I just don't think she wanted to bother with. You know.
Then she added to the list, though, people that were not even recommended, or
My
at least your client.
My client, yes,
Okay.
she added him. So he was one of the ones. So there were some people, you know, and it's publicly available in that book, like Senator Graham, Loeffler, those Perdue, those people.
They recommended prosecuting them?
Right. She had considered prosecuting them and taking them off the list. So there were a lot of people that had been on the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, you know, why would you want to expand it? You know, there's different ways you can go about prosecution.
Did you figure out why they add your client to the list?
No, but the my allegation in my motion is
Money.
that, you know, the bigger the case is, the more money.
Oh, boy.
And that, you know, that made sense to me. So for me to file the motion to disqualify, obviously, you know, we had to have some type of a basis, you know, besides all of the violations. And so expanding the litigation, because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, follow me down the path, if you only indicted one person and it was narrow, you know, you could try it in a month. If you indict 19 people and, you know, 3 different essentially alleged criminal schemes, you know, like I divided it up earlier, that you now have 3 years of
when
trial.
she was going through the bank records or how much he got paid, that man was getting paid like $35,000 a month. And the other people was only getting paid like $2,000. Boy, they milked them.
You know, you've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial motive, particularly since my client was not recommended by the special purpose grand jury to be indicted.
And you had the data to show that she was financially benefiting from the continued prosecution?
Yes. And so to answer your question, you were saying walk me through it. So January 8th, I have a deadline to file this. So I'm verifying, you know, and that's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it, and at that point, the world is shocked. I mean, shocked, because nobody had any idea. This had been hidden. This was even hidden from her father, who she had testified she talks to 10 times a day. So very few people knew about this relationship.
Oh, she telling
and
it
so
all.
they very much wanted to know who knew about it.
telling it all.
Mr. Bradley, that next weekend, you know, he gets some calls about, he gets a call, you know, trying to fish to see if he's the leak, is what it was couched as. He gets a call from a gentleman named Gabe.
So you don't
Banks,
hear
who
that?
ultimately-
Ejection, this and that. Hey, no, wait, blah, 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 blah. Nah. They just want to know they didn't want to know the facts. What you got, let us know. We're going to do, and we'll see what we're going to do about this.
Represented Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fani Willis?
Yes, and I've not gotten it. I've not opened records it, but I have been told that Mr. Banks also has one of these special counsel contracts. Again, I have not opened records that, not part of my case. But so he calls Mr. Bradley, and Mr. Bradley calls me and another friend of ours. Her name's Cindy Yeager. She's a district attorney in Cobb County. And, he was upset. I talked to him. It was, I believe, a Saturday night, and I could tell he was upset by his text. I left my kids and went and talked to him because I was worried about him. And, he took it as what he described to me as the first shot against the bow, that they were trying to figure out if it was him, and they were trying to silence him. And
trying
Gabe
to
didn't
silence him.
Mm-hmm. And he said Gabe didn't say anything that threatened him. He just
I want to
out
show
of the
y'all
blue
something. I
called him.
want to
And
show
he
y'all
hadn't talked to
something.
him in quite some time. So it was out of the norm for him to call. So Mr. Banks called and told him that was asking if he was the leak. Meaning if he was my source. And Mr. Banks said that it was because he had seen a news article, and Mr. Bradley knew that wasn't the case, so he said, send me the news article. So he sent him some article that did not say he was the leak, and that put an end to it. But then the next day, Mr. Wade called Mr. Bradley's best friend and said to call, he didn't call Mr. Bradley directly, but told his friend to call Mr. Bradley and remind him of his privilege.
It's an attorney-client privilege.
Yes.
Who's the best friend? Can you tell me?
I'm not.
Damn it,
he told me
I can't do it. I'm
his
going to catch
name,
it, though.
and I'm not positive. I think I know who it is, but I'm not positive.
All right. So Wade calls Bradley's best friend, says,
Okay,
you better
check it
call
out.
Bradley.
Look at the homies. Look at the homies back there. I ain't gonna say homies. I'm just talking in general. They ain't my homies. I'm just saying. Look at the people back there. The dudes that surrounded him. All the people back. You see, look at the two black ladies. And the five Caucasian men sitting there. Yo, look at their face. They are not playing.
Remind him he's got attorney-client privilege with me, and he better not spill the beans.
I do know the best friend works at a law firm called Beasley Allen. He told me that. He said his best friend's name, and then he said he works at Beasley Allen. And he was pretty upset about it. And it was the same day of Miss Yeager's birthday, so he didn't want to call Cindy, but he was upset, so he called me, and we talked about it. And we were both pretty upset about it because it seemed, why.
Tampering with witnesses.
And they're not
seemed
racist. They have 4 black people with them, so y'all can cut that out. I ain't trying to. Don't even go down that road.
Tampering, and it's just, it's just an uncomfortable position to be in, and all of us were kind of worried how the state would react to all of this. But at that point, it's
Did
still.
he interpret that as Miss Willis trying to intimidate him from revealing this affair?
Or Mr. Wade.
Okay.
He took it as intimidation, yes.
Right.
Because what he called it as is the second shot across the bow. Those were his words. So he said first shot across the bow was Gabe Banks, second shot across the bow was Nathan Wade calling.
Okay.
So that's how he interpreted it.
So he
but
did
at that
call
point,
him.
I had not disclosed him as the witness, as the primary source. So nobody knew that, and I was trying to protect him as much as possible. Just because I knew he didn't want these calls. It's not something that you want. So they filed some motions to quash.
Nathan,
and
you call
I had
that man?
to
Quash what?
to quash all of the subpoenas, pretty much every subpoena that I had issued.
So after you filed this motion to disqualify, I guess a hearing was scheduled?
Yes.
And
Yes.
then you started issuing subpoenas to line up your evidence?
Yes.
That's when this witness tampering occurred?
Yes.
After that, to try to intimidate your witnesses from coming to court?
Yes. So, and let me walk through the timeline. So I filed
I
this on the
told
8th.
you, yeah.
The next thing that happened was Miss Willis testified. I say testified. She spoke at a church on Martin Luther King Sunday, and was making some statements about why did they single out Mr. Wade. Didn't say anything about that we singled him out because he's the only one she's having an affair with.
Can't play
Did
the
not
black card
agree to
all the
that.
time,
Instead
y'all.
said that it
Come
was
on,
racially
man.
And the other 2 special prosecutors were white?
Yes.
But they were making significantly less money.
Right. And she even said, to the church, she even said that I'm paying them the same rate, which is not true. Mr. Floyd's contract is for $150 an hour. It's never been $250 an hour. So that, one of my kids was listening to it and
Fani.
said, come listen to
They
this. And I
gon-
listened
they
to it and I
coming.
was like, wait,
They-
that's not true. So that was one thing that she said that wasn't true.
Yo,
Also that it was racially motivated.
Hey, I wonder if they're gonna get scared and do some stupid stuff. This Fatty God, dog. I don't know. See, it's entertainment or whatever. I don't know. Don't y'all know people out there? They feed off y'all negativity. Don't you see what I'm saying? People feed off the stuff that you do. You know what I'm saying? I mean, I know we on the planet and we ain't supposed to be all happy-go-lucky, running around jumping through rainbows and all that stuff. But hey, man, people feed off this stuff.
Motivated. She did not.
Probably me too. because, hey, I'm locked in. I'm locked in.
She didn't say anything about, yeah, they're singling him out because he's the one I went on all these vacations with and he's the one I'm romantically involved in. Instead, she said that we were singling him out because of race. And then she said that they were all paid the same, which is not true. So I thought at that point, okay, they're not going to admit that they have this relationship. And so I'm
My
texting
thing
with
is
Mr. Bradley, oh my gosh, are they going to lie about this? Like, it's on their credit cards. Like, I don't know what's going to happen here. And so then in the divorce proceedings, Ms. Willis had been subpoenaed to testify.
That's all I got to
and
say.
she actually invoked her executive
Don't
privilege
get caught.
as the DA.
She wouldn't testify.
She would not testify. So
Then they settled it.
Right, and then they settled it because because the judge said he was going to have to testify. So they settled it, and he did not have to testify. So at that point, the judge had given us a hearing date, so I was able to issue subpoenas. So my subpoenas started going, and I filed the returns of the subpoenas, and all of a sudden the motions to quash started coming in.
She's smiling.
Right around that time, the state filed their
Happy to
response
tell.
where they admitted
Happy
to
to
this
tell.
relationship, but they put limits on it. So so their response that they filed, I believe it was the February 2nd, I believe, February 2nd. So on February 2nd, they filed their opposition to our motion. They admit that there was a romantic relationship, but they claim that it started after he was hired and that all of the gifts and travel was roughly divided. They submit an affidavit from Mr. Wade, and they submitted a receipt from a credit card where she had paid for one plane ticket. So, it was a couple $100s on hers and then thousands of dollars on his. So then my subpoenas were filed, and every single one of them had a motion to quash. And they kept saying, I don't have a good faith basis, I don't have a good faith basis, kept very harshly saying that I was making this up and nobody had told me this and it was, gossip and I was lying and I should be sanctioned. So the court held a hearing on their motions to quash, and I was forced to disclose Mr. Bradley as a witness, which I did not want to do because I was worried because I knew they had called and all of these things, but I had to disclose him as a witness. And so at that point I was still talking with Mr. Bradley fairly regularly, but that then changed.
Okay. So you're waiting on the judge to rule on your motion to disqualify?
Yes, sir.
Look at him.
In summation, the grounds for that are what? That this is improper
Look how old boy looking at him. Like I heard enough. He ready to go. He ready to go lock him up right now or something. Fani, y'all might be going to jail, man. Y'all might. I don't know. This is not looking good.
Prosecutor to have a relationship with the special prosecutor?
Look how they
Yes,
look.
it's a conflict of interest.
Okay. And that's because of the financial benefits or just because?
Mainly
What?
the financial benefits. There's a couple different aspects to it. We've also alleged some other misconduct because the prosecutors aren't allowed to publicly condemn an accused prior to trial. And she made a speech at a church and said this was racially motivated, talked extensively about the clients being guilty. She testified at our hearing that our clients were guilty, that my client was, guilty of trying to, I don't even remember, subvert democracy or something. But she's made a number of public statements condemning their guilt, which is not allowed.
That's inappropriate.
That's how you know she's telling the truth, because that's when you talking to somebody, she say like, I don't even remember. You know what I'm saying? That's like she's focused, but it's like it's like if you ask somebody something and you be like, yo, did you go to the baseball game last week? But so much stuff going on in your life, but you just so tired of it or whatever. You like, man, I think I did. I don't even remember, man. That's like a true line. That's like the way your body language is. You know what I'm saying?
For a prosecutor?
Very much so. And there's case law on that. There's bar rules on that. So there were a lot of public speeches that were made along the way. And, they're you can kind of follow them through this media monitoring company. But so she makes these, and then she got disqualified from prosecuting another person she wanted to prosecute.
For making public statements?
It was for a fundraising. She had thrown a fundraiser for his opponent, his political opponent.
Right.
So when that happened, you sort of see her press stuff dwindle a little bit. So she stopped making as many public comments. But then when this motion came about, she made the church speech, as I'd call it, where she, calls me and, my client, racist, and says, condemns their guilt. And then she also gave interviews to this book. I don't know, the timing was just, it was just nuts. But the book came out right around the time that all this was happening, and it's called Find Me the Votes. And
that came out in 2024, you're saying?
It came out a month ago, if even. And she
Perfect
she
timing.
literally let the authors of this
Perfect
book
timing.
in when she was
Right, with
deciding
all
how
this stuff
to
going
prosecute
on.
this case, who to indict, who not to indict. I mean,
Smart
their whole
move.
thing is that they
Smart
have
move,
unfettered,
Fani. I see you.
behind the scenes access to her thought process and stuff. So, and she's talking about all of this, that they're guilty, but the big
gonna make me a
thing for the
podcast
forensic
called
misconduct is
Ask the
she's,
Rapper.
in the church speech, she's saying, and she says this in the book too, that God has told her to prosecute them. So the theme between these two things is that God told her to do this, and that she is doing the will of God by prosecuting them.
Oh, Lord.
And that is,
That's unethical.
Yeah, come on.
in my
now.
opinion,
All right, so
God,
there was,
dog, Fani.
I'm trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was new to the state Senate as well, because all of this began on January 8th, which is that the day we started, 8th or 10th or something?
It did, and that's-
it was the day session began, and all of a sudden these bombshell allegations come out, and I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues or whatnot. So I remember she wouldn't testify in the divorce case.
right.
But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify.
Yes.
Okay. And in that,
As they were arguing the motion to quash.
I wonder, okay, so in that testimony, did she deny the start date of this affair?
Yes, she said it started in early of 2022. There was some discrepancy between
She
them,
said Fani
a month or
came
two
in
here and there, whether it started.
while they was-
Generally, it was around March.
She
is when
did. She kind
Mr.
of
Wade
did.
was-
What are the
Kinda just walked in
consequences
there,
for an
man.
attorney
Like a raging bull.
to give sworn testimony that she did if you're Bradley, what is it, Yerke?
Yerty.
Yerty, your Trackhawk data, your other independent verifications are found to be truthful.
It's a crime. It's a felony. You'd lose your license.
Okay.
It's perjury.
Same for Wade.
Oh,
Yes.
See, it's
And we have rules that are one of the, outside of privilege and confidentiality,
See
we
how
cannot
quiet
support
it got?
perjury. So if I have a client
You
who
don't like
tells
that-
me I
that
did it, I
quietness.
can't put them on the
Uh-uh.
stand to say I didn't do it.
Okay.
I would lose my license over that. I cannot do that.
And Yerty came to court and said, oh yeah, this started in 2019.
She saw them, she saw them together. She testified that she saw them romantically together, and, they were very close.
Yeah. And
boy. You see how everything
you
got
had
quiet.
Bradley's text messages
nah,
showed he
Fani.
confirmed that absolutely back
Yes.
in January.
Yes, and he had a lot of
Before-
details, little details that matched up.
Did you get other details from him by phone?
Yes.
That wasn't in the text? What did he?
A garage door opener that Mr. Wade had a garage door opener, and then I've subsequently learned that he told Mr. Aurora the same thing.
Garage door opener to her place?
To her place.
Okay.
Yeah, to her place. There were other things. Just a lot of context. Things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about that they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash so that there wouldn't be a record of it.
Okay. All right, so I'm a little puzzled by the legal standard. I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now. And I'm not the best person to explain that. My husband argued that part. But, appearance of impropriety, it's one of those things like that if it undermines the outcome, undermines the confidence in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this. due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor, and we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety, and then actual impropriety is receiving money, like receiving money and not paying it back. And there was testimony about that. Ms. Willis came in and testified, and Mr. Wade did, that she paid him back in these sums of cash, but there's no records of any of that or where she got it.
Anything shows him depositing cash or
No,
receiving cash?
No, and we asked her like where you got it. She said that she said she borrowed it from her campaign. So she said the original large sum of cash came from her campaign.
I think all of us up here that have campaigns know you can't take campaign funds for personal use, right?
I'm not well versed in that area of law, but that is my understanding.
It's pretty black and white.
So she testified that she took that the majority of the cash she had on hand was from her campaign. That a loan she had given herself from the campaign.
The dude, he said you can't do that, and she said right off the jump, she testified. That means, Fani, you said that you did that. That means these folks can go back and look up that video, and they know that you can't do it. Oh my goodness.
Very clear about that. And then she also said that when it got low, she would supplement it by getting like $50 back at Publix. But I mean, she's giving him, $4,000, $2,500, so large sums of cash. So, and there's no trail. Obviously, there's no record of any of that.
Right. In some of the documents you produced to us, there were a couple of IOLTA trust accounts. Mm-hmm. Those were Mr. Wade's accounts?
Yes.
Okay. So he had more than one trust account in his law firm?
Yes, he did.
My bad, y'all. Sorry, y'all. I had to take a quick break right quick. But let's get back to it real quick. Where was we at? Yeah, let me find out where we was at, y'all. I think we was all right there. So, let's go.
The documents you produced to us, there were a couple of
IOLTA
trust accounts. Mm-hmm. Those were Mr. Wade's accounts?
Yes.
Okay. So he had more than one trust account in his law firm?
Yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Yes, and so he testified because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners, and then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Campbell.
Do you think Mr. Bradley was aware that he was running the money through a separate account?
I think it might have been part of the reason that they dissolved.
That they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his home bank account?
His ex-wife didn't have any idea. I mean, you could tell from the pleadings that he was even making this much money. He filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
Well, we knew he was making up to $35,000 a month under this contract.
Right, and he has a lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
Okay, so that's. Does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yes.
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever, right?
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money, so they're a lawyer trust account, and essentially what they are is like if you settle a divorce case, not a divorce case, I'm sorry, you settle a civil rights case or a
personal injury case,
right. And you get $100,000, and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out. You finalize the case, you send a settlement letter, you get the amount, and you have to put it in your in your actual business account, and then the client gets their check for their part. So IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it on your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTAs and not have to pay taxes on it until it was a year that
Right. So
financially
sometimes
they wanted to.
attorneys may take a retainer
Yes.
up front and bill against that retainer. Say, you might do that on some of your criminal cases. So, yeah,
Yes.
I'm going to take the $25,000, I'm going to put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
That's exactly what they do with retainers that are refundable. So they would ask, $10,000 retainer, and then if this month I billed $1,500, I send you a bill, and then I take the $1,500 and I transfer it to my business account.
Okay.
As soon as it's earned, you have to transfer it.
So these funds, if they in fact came from the contract with Fulton County, should have probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that, but
ethical violation that can get you disbarred?
they highly regulate the IOLTAs, highly regulate. I mean, the state bar, like there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain.
Okay.
But yeah, so they're highly regulated, and we know these were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account, or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon. You've been very patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions. Under our rules, we do allow at least one member of the minority party to participate. And Senator Jones, you're not time limited. If you, when the buzzer hits and you've got to go to court, you
Okay.
tell us, but I feel like we got at least 15, 20
You
minutes or
definitely
whatever.
do, and I'm happy to answer any questions you have. My court's at 1:15 in Fulton County, so, if I get in trouble, if you can call the judge, then I'm fine.
Okay, so I'm thinking this is probably what the Democrat people now. I think there's like the Republicans holding this, and then but they got to have an equal playing field. You know what I'm saying? So I guess old boy finna come in greater, but it's still gonna get good. I think, man. So from what I heard, I mean it's on fire right now. So shoot. Trust accounts, money being transferred, all this stuff, man. It sounds like some mafia stuff. See? RICO charges. Yo, it'd be ironic, man. It'd be ironic if she end up the one going to let me be quiet.
You got it.
I just wanted to go back to the issue about the conflict, because I think that's kind of what brought us all here to some extent. On one issue, in your brief, the most recent one that you filed.
The second
He's
one?
black,
Right.
so you see what I'm saying? Don't be doing the race thing. I know, but man, look.
Okay.
On page
gotta be
21 of
equal.
that,
Be equal.
you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath?
Right.
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed. And in and of itself, that's not, that's not filing an oath, that's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in an order.
Right.
But I was trying to paint the entire picture and how I felt that it was relevant, and it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right, now I was just kind of showing why I'm moving on to this next particular point
Okay.
here, which goes to page 24 of your brief, which deals with, I think, the thing that's really
Hold on,
out
man.
there.
Is that Mike up there? The My Pillow guy? Yo, why he smiling like that? He love those pillows.
And then
Let me
media,
stop.
which deals with the relationship and aspects of that some kind of way this creates a conflict of interest. And, of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking, you said it was the last one that I filed?
Yeah.
So February 9th,
Yes, page 24.
page 24, you said Woodward?
Whitworth.
I don't see Woodward.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different, the one that was filed February 9th at 3:47?
Ms. Merchant, we can't hear you.
I'm so sorry,
Just
I'm so
pull the
sorry.
microphone
Yeah,
just
of
a little bit
course.
closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
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 Yeah. One that's a little bit more. Okay. So that one there on the Whitworth case. Tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24, okay. So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification, held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me. But essentially, to answer your question, that first of all is physical precedent only. So
Right.
yes, and we
But you did cite it.
and said
Right.
that it's physical
Yeah.
precedent only.
And you're using that as the basis, really, to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth and also amusement sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have the case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other
remember that.
defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical precedent only, and I don't remember the specific facts of that case, but it's not just a conviction. And obviously,
I understand.
the state wants it to be just a conviction, and we argued this extensively over 3 hours, I think, in front of the court, but it's also a
I ain't
personal
gonna lie
stake.
to y'all right now. I'm lost. I don't know what they talking about. But look like the brother man trying to dish one out to her. I'm just saying. I'm just talking. Don't get all crazy. Come on.
In the prosecution, and that was an amusement, prosecution. In that case, that was a contingency fee case. So
That's
that was
correct.
completely different. Yeah.
And so in
And for
amusement,
the
it was
record, look, I'm not with all this Ashleigh merchant and the Republicans and whatever. I'm just saying, but based on common sense, the stuff that she's talking about, the stuff that Fani is doing, from my eye perspective, you're looking kind of weird. You're doing some weird stuff out there. I tell you what, you do some weird stuff around me, you got to back up because I don't want you around me.
contingency fee case. So they had a personal stake, actually,
I
really
don't
in
care.
the
I don't want
conviction,
you around me.
because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake and just bringing the case, because he can't have there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture action.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
that's the only way they get money.
Yes.
But they don't get money for
conviction.
bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a conviction.
But they only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still
Absolutely.
Make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, oh God, that's a long answer. The actual conflict is lying on your disclosures about how much money
I'm talking
you
as far as this issue is concerned right here. When you use the with worth, you use amusement sales,
Nah, bro,
and they
you
say
gotta
that
listen
there
to
has
the
to be an
whole thing, man.
actual
Come on, man.
conflict
Oh,
in amusement
man.
sales. And let's go back to Whitworth if we can. Because in
come on
Whitworth,
now. You on one topic, bro. You gotta switch it up now. Come on, man. And plus, on top of that, I think the case you're talking about casino money, gambling, slot machines. Man, boy, look here, man.
the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction.
Look at little buddy right there, boy, holding his hand over his mouth, like he looking like you talking about you talking about a case about slot machines.
Because what had happened was the defense attorney came to the prosecutor and said, we would like to plead. Mm-hmm. And the prosecutor basically said no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so
I don't
the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor, we want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taking place?
It's not in the trial. So
I
it's not
can't.
limited just to the trial. But to answer the first part of your question, when you were asking about the conviction of personal stake, Ms. Willis has made numerous public statements about her interest in a conviction.
I could tell I could tell you the wrongdoing in the trial if you want to know. I'm just saying what I see and what I think. Okay, but what Fani and Nathan, what y'all doing up there at that White House visiting?
Emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case.
With a $5,000.
But it was going to end.
It
There would
would.
be no more billing on that case, because earlier you
Just
said,
mine.
that you believe.
Bro,
which is
see,
total
this is what I'm
spec-
talking about. Sometimes I need to be in places, man. You know what I'm saying? He said, he tried to end the case, but you got to think about it. They indicted like 19 people. You know how many appeals and all that stuff that couldn't happen? Donald Trump gonna appeal immediately, automatically. I already know that. You know how long that's gonna drag out? They trying to get this done rapidly before the election. Stop playing with people.
That they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
Oh, I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said, I believe that they created this case against my client
Right.
so they can continue to bill.
Not
Well, he
just my
basically went out and said, I'm tired of billing. I'm going to offer a misdemeanor.
Okay, let
And
me-
you said no.
Take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it a little
Damn,
more
bro,
detail.
breathing heavy.
I tried to explain that there are really 3 classifications is how I broke the indictment down. There's the folks that are
He's
involved.
breathing. I can hear him. I can hear him in the headphones. He's breathing heavy in that microphone. So that means you up to something. You got. It seems like you plotting. I don't know, man. I don't know. But go ahead. Hey, you got to be equal. Let them get their questions off.
The federal level. You see those people having, they were in D.C. Then you see the electors. Then you see coffee. These cases could have been
Ms.
handled.
Merchant, we can't even hear you hardly.
Oh, I'm
up
so
here.
sorry.
Just pull it
I didn't-
up right
sorry.
to you. Pull it to the edge of the desk if you have to, so everybody
Okay.
can hear.
Sorry. Okay. So how I was trying to explain it is I separate this down into 3 different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle, by putting them all 3 together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. They expanded it to include these 3 different classifications. What does that do? That means the trial is going to be a year. They can plead people out. They can plead Michael Roman out. They can plead this person out. They can plead people out. But they're always going to
got
have
like
that
19
large
people
enterprise.
in there,
and it
man.
actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking up time with you. It still expands it. So my whole point earlier was that this expands the litigation because imagine if we just had, like you see in other cases, one defendant. You can
Bro,
limit the
she's the
information.
president of the criminal office or whatever she said down there. Oh, she went through her, they asked her what she do. She went through a whole list. She's like the president, attorney of whatever, of the law, or the crime, whatever, man. The lady know what she's talking about now. And bro, you got to come with it, man. You see how she double back on you.
to just that crime and that case. Or you could have 3 separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them, to have 3 trials because there's no courtroom that can fit all of those people. So that expands the litigation.
So in the case that you cited, physical or not,
Which one? Whitworth?
Whitworth, it says specifically that when the prosecutor goes up, Morgan, who is the person who's not supposed to, who's talking to him, who's the prosecutor, Hobbs informs Morgan, who is the prosecutor, that he anticipated a successful criminal prosecution, but that any decision regarding Whitworth's proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward. And they said that was not a conflict, that was the prosecutor's decision to make. And you're saying, this is the case you cite. Well, in your case, they actually came to you and said, we're willing to give you a plea. And you said no, which is perfectly fine. But then you say, well, they want to extend prosecution on my client. They were willing to cut it off. And so therefore, the case that you cite is totally opposite than the situation that you're dealing with.
Nah,
How
bro,
would you
I see what
say
you're doing. I see what you're doing. Nah, see, so basically what he's trying to say is like, okay, you making, if by Michael Roman not accepting the plea deal or whatever, you dragging it out, and the more that is dragged out, this is why Nathan Wade and them getting paid the money and all like that. But why you gonna plead out if you ain't did nothing wrong? If you feel you ain't did nothing wrong, you ain't got to plead out. You know what I'm saying? Hey, anyway, he had all that money. They had all that money going on. You know what I'm saying? I'm good. If I had like 700 bands in the bank, I'm straight. I'll start pleading them out too.
You have have a conflict in this case.
Man,
Based
people
on this
think people
case,
are slow.
just based on this case.
They use
that
big
was your
words,
first case
but,
that you
man.
cited in your brief.
I don't think it was actually the first case, but
The first was actually a federal case, but the first Georgia case you cited was Whitworth
think
on
it was
this
Whitworth.
particular issue.
Right, on this particular issue.
Correct.
And again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got is we've got these financial disclosures where they're not being truthful. Ms. Willis is lying under oath, which is the same thing my client is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which we have seen, unfortunately, drag out over the last couple months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is
I wanna
a
back
conflict
off
of
of it
interest.
now.
And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is, we have to
Who
cite
actually brings the case?
the district attorney. Well,
How do they get the case?
well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Waite. So he's the one that presented most of the witnesses,
How is your client charged? How are these clients charged?
My client was charged just in the actual grand jury.
Okay,
Yeah.
so a grand jury.
Yes.
Okay, so we had a special grand jury, and then you had a grand jury
Yes.
who made this determination.
Well, yes.
They
And
made
I-
a determination to bring charges, basically, to indict, correct?
Yes, and I.
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this. It is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident. And the grand jury indicted
So
him.
you're saying the grand jury has flaws?
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the accusations?
No.
So the
and
grand
I know
jury-
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
Correct.
Definitely, but
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. And they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. The prosecutor brings that indictment, and then they vote, and it's a majority. So all they have to do is a majority vote, and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally, you've got a standard of 25%. I think there should be
Boy,
much more
she's
safeguards
spitting
on the grand jury
flames.
process, personally, but that's for another day.
So you went through special grand jury and they made their recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3?
2 or 3 already.
And they were well, there was one, so the first gentleman who pled, he was a bondsman,
Yeah,
and he
see?
was not.
It's like 3 people or 4 people, and Cindy Powell, one of them, right? You know what I'm saying? They already played it. They played it and wrote their little letter, blah, 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 blah. You know what I'm saying? But at the same time, that was only 3 or 4. You still got like 15 more to go after this one. And I think Mike Roman was up next. I think he's like the 5th one. You still got like 14 more to go. And look how long it's taking them.
Because of the state law for bonding agents, he's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he didn't enter a plea. And I mean, he got probation. It was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other 2 people who pled are both lawyers,
Facts.
lawyers at the end of their career, and I can imagine when I'm
RICO
close to
case,
retirement
what,
and I
ain't you supposed
have
to go
my
to jail or
retirement
something
funds,
like
if I
that?
would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualifications. So,
Oh, yes.
But you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I guess, from state side. He's able to go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral in
that's
that.
not surprising at all.
And he's going to go into a grand jury, and you say he's integral in that. Then why even say that he's unexperienced? And he's getting people to plead guilty. But basically, you're saying those are just lawyers that don't want to do anything anymore, and they just pled their clients guilty.
No.
I understand.
No. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So he did that along with Mr. Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they've walked this case to this particular point. Very complicated case, I'd imagine.
I mean, that's something that we could debate. If walking someone through the grand jury, the special purpose grand jury is complicated or not. Asking questions, and again, there's a team of 10 lawyers. So
now there's a team of 10 lawyers.
Who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and restricted in their private law practice? Why do they need him there when there's all these other people? As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent. There's no adversary. There's no judge.
Once it became adversarial, you've had persons start pleading. And maybe more potentially, correct? Possibly. But we'll find out. But let me ask you this, though, because you were talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case
Kinda
within
cocky,
your
man.
office, just speculating.
I see you, bro, man.
To some extent, we all are. The office would basically shut down. There's a potential that the DA's office had actually basically shut down.
Oh, God, no. If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you hired 5 new inexperienced ADAs, they're not tackling this case. And also,
Well, the inexperienced ADAs are not going to make $200,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is that job that you're talking about that you're going to hire with that, with the $1 million that you'd have paid him.
Yeah.
If that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just you're just saying the money you paid him, you could have done this. Because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So I understand the back and forth.
They
when persons
renewed it
are
like
saying,
3 times, didn't they? I know they renewed it two times. But when Bradley was up there, he was like, he was looking through the thing, he was like, I know there was one before this one. So they done renewed that contract. So ain't no short time in it.
they could use this money for that. But that money was delegated for him on the short-term project, so to speak. So it's not anything
$1 million
that a person would come in
short-term
long-term
money.
and actually necessarily do. But at the same time, that would be up to the district attorney to make that decision how she's doing that. I just make the point that
Need me a
so
job, I
far,
get $1
from a
million
district
for
attorney
3
standpoint,
months or
I would
some
say that
shit
they
like that.
probably believe that so far the case is successful. And we can argue about what's qualified and what's not, but certainly I think that they would
He
argue
must ain't paying
that this-
attention to what's going on over there in Judge McAfee courtroom. He said his case is successful. Do you, what? You must have been watching TV in the last week or two.
point the case has gone from a successful pattern for somebody that's been denigrated and said is totally unqualified. I did want to go into these trips. How much
thought-
was
wait.
the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Okay. I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, you know, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all. Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, is delegated to him because that contract can end at any time. She could say, "Hey, the contract," because he works at her pleasure.
Oh, yes.
So that contract can actually end at any time.
Yeah,
That
he's
would
working
be
for
the
her
point.
pleasure.
Yes,
On the trips, how much total were the trips?
about $20,000.
And I think it was about 17,059. But even if we say 20,000, what was the average cost of each one of those trips?
I don't know.
Well,
You know, unfortunately, they did not provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you. Most of it was paid in cash, so there's no record. So I wish I could tell you, but
going by your slide, one was 3,335, one was 4,453.
which one? Hold on, I want to make sure I'm clear on each.
You had 6 trips.
Okay, but which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up for me, please.
Yeah.
There we go.
Okay.
So the first one, Royal Caribbean, 3,335, Aruba, 4,453. And then we see the next one, and then the next 2. How would that compare? I mean, what is that so unusual on price point so far as trips are concerned?
No, I mean, I don't think so. The Royal
What?
Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabinet. So they have.
Look, it's not about. If I had $5,000, I go take a trip. Of course, I'm probably gonna spend like $3,000, $4,000. They're not talking about that. They talking about the money that they getting to spend it. This dude, he trying to twist it up, man. You don't worry about it. Don't worry about it. See, this is what I'm trying to say. Like, I'm not no Republican. I'm not no Democrat. I'm not none of that. I'm for what makes sense. You know, why are you trying to? You being kind of weird, man. You trying to say weird things. Like, you trying to twist it around. Like, you trying to forget about the fact that she paid this man over almost they talking about $1 million. In the time since this case happened, and the dude that's the high top paying dude, you only paid him $150,000. The dude wrote a book and everything about it. The other 2 prosecutors, that's along with Nathan Wade, you paid one of them 25 or 200, what? 250,000, and the other one 150,000. But you paid the boyfriend. Now that everybody know that you're sleeping with, but you pay him over almost $1 million. And as the case keep going, you're gonna keep paying them more. Look, stop playing with me, man. Look, they up in y'all head.
They had 2 cabins. His mom had a cabin. They had an oceanfront balcony. You know, for the Bahamas, I think oceanfront balcony is probably, you know, upper middle, but I don't know that it matters.
See, they say that because, man, you be black, man. You know what I'm saying? Be black. See, that's first of all, I ain't black. You know what I'm saying? Do I look like this microphone? Do I look like this microphone? See all this black and white stuff and all that stuff? Do I look like this microphone? I don't think so. So stop playing.
You know, comfort class, not unnormal for a lawyer. I mean,
You know what maybe the average American spends on vacation?
not this much.
You
don't
make it
think?
so bad while we on it, you know what I'm saying? My skin tone ain't even the same color as my hair. Talking about black people. Man, y'all need to, boy, that's probably, y'all need to wake up.
Have you looked?
Huh? No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these trips.
Well, you know, if you, since you speculate a lot, I could speculate and say that you did look, and that's why you didn't put it in your brief.
I did
Because
not.
Forbes actually says that the average is about $3,700 that a person spends on a vacation.
For a single person
I
or a
just said
family?
Family of four. Well, at that time, they were taking 2 and 3 at the time.
That makes
so
sense.
that makes that's about
no,
normal.
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said $3,700 for a family of 4. That does not surprise me. For families that can afford to go on vacations, does not surprise me.
So it's basically what the average American would do.
So that's
Yes.
this is half of that for 2 people. So you said $3,700 for a family of 4. This is for 2 people,
Right. It's just 2 people.
right? So
Yes.
yes.
So it wouldn't necessarily be average. It's 2 adults. Bottom line is it's not extravagant. It's not lavish, is it?
Look,
The
man, you
long
better
list
watch
is
out because even I knew the answer to that. You know what I'm saying? That's what they spent for 2 people. $3,700 for 2 people. Do the math. Do that times 2. That's what? That's 74. That's 7,400 for a family. Yeah, you're gonna spend more because you probably got kids. So that's 10 bands. If a whole man, come on, look, bro.
So,
But it's not lavish.
that's one of the reasons I didn't include all the Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamans. I didn't include that. I didn't want to do the math, and I also did not want to.
And how much does Ms. Willis make?
200 and something thousand a year.
And so
It's in my brief.
your argument is that a person who makes $200,000 a year is actually setting up prosecutions to go on a trip that costs $3,500.
That's what they did.
That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about isolation. I'm
But they
talking what's
did
in
that
briefs.
anyway.
I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip for $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise for $3,300. I mean, that's your argument. That's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So we did
What else
argue
is
for
in the
about
brief?
3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in
courtroom
at
on
the same
fire,
time.
boy.
You can kind of assume because it's from the airport to the hotel, but I did not want to speculate to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are
That's
on
what's in the
trips.
brief.
Yes, the ones that I actually had hard numbers that I knew that she had. Yes, that's in
I
the brief.
wonder
Her business.
because this must be a Georgia thing. I wonder if little buddy, if he probably know them. He probably know Fani and them. The way he talking is I don't know. I don't know, man. It seems like you kind of, oh man, I don't know, man. But you got to be equal. You know what I'm saying? I don't know, but I tell you what. Some people you can't fool, man. You talking kind of weird, man. Talking kind of weird.
We deal with proof, and so that's the proof that we
Exactly.
have.
That's what I
That
did.
person
Yes.
is doing all of this for that.
Right.
Okay.
Oh, yeah.
I
And
understand.
so what I included was what I had the actual hard proof of. And then some of it's attached to the brief. Some of it I got by subpoena. So some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted. And there were a lot of other receipts that I had that I did not know for sure if they were joined, and so I didn't include those. And I haven't talked about them today.
Correct.
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. That. So my next question then becomes, going to conflict as far as his salary is concerned, just curious. Is it the amount of salary that you really creates the conflict? I mean, because we get
I
stuck
hope this
on
ain't
money.
finna do nothing. Man, if he finna say it's a jealousy thing because he getting all that money, boy, I'm gonna cut this off, y'all. I ain't playing.
Lot. So is the amount of salary that is creating this conflict in your mind?
No,
or
it's
it's
the
just the
fact that
fact that
they-
he gets any salary at all?
No, it has nothing to do
What?
with that. I did
Look.
not make any allegations against Mr. Floyd or Ms. Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on, and they were hiding it from the taxpayers.
Which we just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict.
Oh, I do, because of the Fulton County laws. The laws say that they
I'm
can.
talking. I'm not understanding the county codes, but I'm talking about as far as like what the case law says, which is
Oh, yeah.
what the judge is actually going to. If they're not
Come on, bro.
hiding that or against the Fulton County ordinances,
They were hiding it, though.
do you believe that there's a conflict? If they brought it out and said, "Hey, we dating," is it a conflict in your mind?
They only brought it out once I alleged it, and they called me a liar multiple times.
What I'm saying is that they brought it out. Would it be a conflict in your mind?
If
Is it
they-
a conflict?
Here,
Of course
in a-
it would
And
be.
what would be the conflict?
So in a perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is
She
brilliant.
said it
and he-
herself. Fanny, you said it yourself. You would never sleep with somebody that work up underneath you or with you. Because it'd be what? A conflict. Dude. I'd have played that video for him and be like, you answer the question.
An amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house that Fulton County's paying for and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J, knowing that, Exhibit J, we wouldn't be here.
So then your client actually has no conflict because that would still exist. Your client has no hard conflict then. There's no actual conflict. It doesn't matter if you disclose a conflict. If you disclose a conflict, it still exists. And that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you, and I have a conflict, and I'm going to go testify against you. Conflict is now over. Absolutely not. If you have an actual conflict where your client is harmed, just because they disclose it doesn't end that conflict. So what
No.
you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot waive a conflict like that. You
No,
just could.
so-
If your client is, you could not do that for your own client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says,
What?
oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
I'm sorry, I don't understand.
Bro, is he talking about bodily harm? Wait a minute. Y'all help me out, man, because he just lost me. I ain't gonna lie to you, he lost me. He talking about conflict is a bodily harm. Of course, a conflict, if I got a conflict with somebody, I mean, we fist fighting, yeah, I mean, of course, you don't get harmed. Shit, I might probably get harmed. You probably get harmed as well. But what that got to do with them visiting the White House? She paying that man money. They say he ain't never did a felony case. They went on all these trips. They told people they was gonna harm them if they talked about it, threaten them on their license and stuff, demanding, coming in the courtroom, slamming things, and I don't know, Fanny, you looking like a gangster right now, man.
I don't know what
You
you're
don't
asking.
have a conflict if you're saying if she disclosed it, it would go away. Then there is no conflict.
No. I did not say that. I said we would not be here if that had happened.
Right,
That's
because
what I
you
said.
wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the
Right.
state statutes that
Right.
we wouldn't be here because it wouldn't have been
It
approved.
would have probably
But if she disclosed it, not the way you said
I
it.
got you. I understand what you're saying. I understand. Ashley, I'm with you. I feel you. I got you. Bro, you tripping. You need, hey, Uganda. Look, man. Look, know what I'm saying? Look. She basically said, yeah, of course it wouldn't have been no conflict because if they follow the rules and regulations that the Fulton County people down there in Georgia put in place, you know what I'm saying? Nathan Wade and all this stuff, he wouldn't even been hired.
If
If it was disclosed, it's disclosed now. What is the conflict?
The undisputed facts, the facts that we all, your side and my side.
How is your
whoever's
client
side-
harmed? That's my question.
Hold on, I'm trying to answer your first question now. So if all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract because it's in contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what could have happened.
What case law do you point to prove that?
Oh, the statutes. It's
Bro.
No, it's not stat, not Fulton County statute. I'm asking for Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And there's not.
No, and it's really not surprising, honestly, because can you imagine this happening? I mean, honestly,
happens.
in December, would you have imagined this happening? I think
Oh, it
most people
happens.
wouldn't
All
have.
sorts of conflicts.
Oh, so it happens, bro. Sometimes, we just, we just go down there and do what we want to do. It happens. Chill out, lady.
taken up by the Court of Appeals.
I
and
can
Supreme
tell
Court.
you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed, because it's the only place that this happens. So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not filing.
Is she paying him, or is he earning the money because he's actually billing hours?
She pays him.
because he's prosecuting the case.
I don't.
He's
I wasn't
billing
there.
hours because he's prosecuting the case, correct? A
I would
case that a
assume- I
grand
would
jury
hope-
indicted.
I would hope that he's billing based on work that he's doing. I don't know because I don't have proof of that, and the billing is very irregular. But I don't know, so I don't.
But I
wanna
mean, words
speculate.
do matter when we say that she's not paying him in that sense. He's earning money for a case that he is in charge of prosecuting, that a grand jury indicted, and that's
Man, I hate to say it, man. Bro, you look stupid. You talking stupid. See, you acting like you ain't. How do people like this get in places, man? Bro, you look stupid right now saying that. Man.
where we are.
You're
That's-
correct. She is not paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender, and every government official that actually exists.
Employees,
100%. And that he is part of that process. And he is prosecuting a case that you're involved in, correct? He is
And Fani hired her boyfriend. It's like you go hire your wife, Mr. Dude, on there talking. If you're married, you go hire your wife and y'all come and prosecute me or whatever. and the state people paying you money, and you say instead of hiring somebody that's not your wife, you hire your wife. You keep it in the family, huh? And y'all take all that money, then y'all go out there and just do what y'all want to do. That don't make no. Come on, man. And then the laws and whatever saying you can't do that. Just like people at work, they know there's some jobs out there. You know what I'm saying? They say that two people they can't even date each other. I know some people that work at a warehouse that can't date each other. You know what?
And he's been integral in that prosecution, and you've said that.
I mean, he has been very involved. Integral to me means that he is necessary.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was, in the case that you cited, it clearly says...
Which case? I'm sorry.
In Whitten,
Whitten?
Whitworth versus State, it clearly says, the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay. Fine.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people, I'm visual. I like to see it. Do you mind?
You guys sit down, too.
Thank you.
While she's looking at this, we're going to wrap up here in a few minutes. I wanted to let the public know how you can get information to us. Each senator on the committee has a separate email address for committee business, and it's simply the last name of the senator. In my case, it would be calcert.inv@senate.ga.gov. INV, obviously, for investigation committee. So each senator, their last name, .inv@senate.ga.gov. And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv@senate.ga.gov. I've had a number of citizens that have reached out and wanted to provide information or be heard or testify possibly in front of this committee. And we are encouraging anybody that has input or information that might be helpful to us to provide it to a committee member, ideally to cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members. We don't have a next meeting scheduled yet, but it will be no more than a couple of weeks away. Ms. Merchant, you may not be able to have completed your testimony today, and we may have to call you back for additional questioning after today, but I'm not rushing you. Take your time, read that.
Can it not be the first week of April?
Yeah.
Cobb County spring break, please.
That'd be fine.
Thank you. Okay, yeah, no, I'm so glad. So this is Morgan. When you said
normal
Morgan,
people.
it should have, J-Tom, it should have struck with me.
Not
I remember
through the
this
spring
now.
break, I gotta go party.
This case,
I ain't did nothing wrong.
So J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk, wait.
Oh, I'm sorry, I forgot the microphone. I'm not good at that, sorry. He took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He was a member of Prosecuting Attorneys Council. And I'm glad you brought that up, because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. And that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue, and the judge pointed that out. That is post-trial. Post-trial, we have harmless error review. It's not a great review. So, it's just like ineffective assistance of counsel. If you stop the harm before it happens, it's a different review than if you fix the harm after it's already done. It's really hard to overturn a conviction once the conviction happens, and that's what you have there.
But in this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about by the harmless error, but they didn't never discuss that because no conflict existed. And you're right, it is post-conviction, but bottom line is you really did not address the aspects that I was talking about when they say is a conflict. And it's not me putting this case in talking about a conflict. It was the case that you guys actually did cite. With that, Mr. Chair, I yield.
Well, can I at least answer that question?
Sure you can.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases. So if there's something that's adverse to our position, we're going to cite it and we're going to explain it. We don't hide behind it. So we cite adverse authority all the time.
Adverse authority, but that's fine.
The oral arguments that we did, that was how the oral arguments started. So.
All right, so that line of question deals specifically with the legal principles involved in your motion to dismiss.
I can see, look, and bro, it's like you wanted the last word. That's how I know you wanted the last word. See, ain't no talking to people that always want the last word. See, when people get to talking to me, or we get our differences or whatever, and then it's like, oh, blah 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 blah, and then they go blah 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 blah, and I'm like, you know what, I did it. You know what, you right. Do you? Whatever happens, happens. If you get hit by a bus, you just get hit by a bus.
As I understand it, you're not really claiming a conflict of interest between defendants, et cetera. It's the conduct of the prosecutor.
Yes.
That
Yeah, there's
is
no
improper
conflict.
Conduct.
Yeah, we're not talking about the conflict between defendants.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget and this contract, that he was not eligible to have been hired had he been disclosed because of, you referred to it as nepotism, but it's relationships.
Yes.
And your complaints are of she's receiving a financial benefit of gifts of more than $100, which violate county policies.
Yes, county and state. So and we attached that to one of the briefs, her return where she filed it under oath that says,
Okay.
I mean, it specifically says if you've got something over $100, you have to disclose it.
And
Here it
then-
is. It's so it's called the Fulton County Income and Financial Disclosure Report, and that says, and it says pursuant to Section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, for purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or seeking to do or doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially giving false testimony under oath if your version of facts is proven to be true.
Yes.
Okay. Keep us posted. I guess we'll keep reading the press as to how your case progresses, I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her prosecutorial strategy and indictment strategy to authors of a book during the course of the prosecution?
Yes.
And
yes.
that book has now come out?
It is.
And
I don't think I brought it with me. No, I have a copy. We admitted a copy at the hearing. No, it's out there. It was published.
Is that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, et cetera?
Yes, definitely. And we alleged that and argued that as far as forensic misconduct. It's very surprising, shocking, and I don't know that there's a ton of cases on it. But that book, Also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Miss Willis had prior to becoming DA. And so, it talks about that a lot.
Okay. Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or a payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified
I bet
that he
she
was.
is. I bet. Look, I make music. I want all my royalties.
Interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
All right. Well, thank you for your willingness to testify before us, and the documents you provided. We'll need some time to analyze and review those. And again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to. We might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all for making time to be here on our committee day. We'll keep you posted further meetings. The meeting is adjourned.
There you go. There you have it, yo. So let me get my takes real quick. And get on out of here. Yo, fire. So it is what it is. But I know they say we got to stick together. But I'm gonna drop this jewel on you real quick before I get up out of here. Black people enslaved black people. Also, it wasn't just white people. The Arabics, they enslaved black people. Black people gave away people to other people. Black people, do your research. I hate to be like this, but first you gotta recognize it yourself. That's the only way you're gonna be able to fix it. You gotta be able to tell yourself, drop your pride, man. And listen. Black people, slaves, enslaved. Black people also. All right, y'all. That's all I got to say. Slavery ain't good for nobody. No matter who does it, it ain't cool. So just because you're the same people that people say, but you're not the same person, that person is in the inside. You see? So, but, because I ain't gonna lie to you, I want to be like, yo, you know what I'm saying? But at the same time, bro, you made a fool of yourself. You know what? I'm out of here. No, hey, my bad. Let me do a little bit of sponsorship. Like always. There we go. Irv Zep Tepe. That's my Spotify. We all on all platforms. If you like music or whatever, you know what I'm saying? Check them out. We got some dope. I got some videos on YouTube right now. You know what I'm saying? My latest one is In Denial. I got a new song coming out called Independent Lifestyle. You know what I'm saying? That's dropping about another month, in a week or whatever. You know what I'm saying? So that's going to be dope. Y'all check them out. And if you like the song, and it's in, you know what I'm saying? At my outro, you know what I'm saying? That's me. It's called In Denial. I'm going to link it below. You know what I'm saying? It's on it's on all platforms. You know, the video is on YouTube. So if you want to check it out, matter of fact, I'm probably going to put it up at the end credits. So y'all go ahead and check it out. Hey, man, Ashleigh, you know what I'm saying? It don't matter if you're white or black, you know what I'm saying? It don't matter. Just do the right thing, man. Do the right thing. Spike Lee out here. Yo, 100, man. I'm gone, man. Peace. Hey, yo, a lot of y'all say you're hot. Some of y'all in denial. Yeah, yo, how you know what she did to support her kids, son? How you know? Yeah, yo, you say that's your boy, but you better say watch him. Yeah, yo, why you think you know everything when you know nothing? Yeah, yo, I threw away the gun, y'all. No, I'm lying. I grip iron, protect my life like I'm not dying. Y'all stop trying, mama stop crying.